right, everybody. It is Monday, April 1st. Happy April Fool's Day. Hope you can hear me okay. I have been here in my room about 5 minutes. I just got back from the courthouse. It was an eventful day at the courthouse, day one of jury selection, and it's one that I won't forget. Let me know if you can hear me okay. I had to get everything set up here today, and I want to let you know what happened today in the courtroom. It was a little surreal, I'll be honest with you, walking into the courthouse, going up to the fourth floor where Lori Vallow had her trial just 1 year ago. It felt like I was there last week. It felt like I didn't leave. All the bailiffs were the same, saying hi to each other. Of course, there's been changes with the defense team and the prosecutors team as far as the attorneys that are on the representing it, and of course it's a whole different case. But boy, it was surreal. It's surprising to me how normal it felt. A lot of changes that I want to go over this trial compared to last trial, and I want to tell you exactly what happened and where we stand tonight, because we have got to get the magic number is 50. So what they're doing, what Judge Boyce is doing this week. By the way, thanks for joining us. This is Courtroom Insider. I'm Nate Eaton. Court got out around 6 o'clock, got to my car, rushed back here to the hotel, didn't even have time to put a graphic on the TV behind me, so we're just going with it. Let me know where you're watching from, and if you have any questions, and we will get to those tonight. We have a great guest coming up, John Thomas. He was Lori Vallow's attorney, one of her attorneys. He's going to be with me to talk about the death penalty, which of course is a big topic, was a big topic today during jury selection, and will continue to be a big topic until the end of the trial, because Chad Daybell is frankly looking at the death penalty or life in prison, and that's what we're looking at today. So here is what we are going to talk about tonight. I believe, if I can pull this up. Okay, there we go. For some reason, my computer froze up, but hopefully you can hear me or see me, actually. Okay, if you can see this graphic, it is day one of jury selection, and this is one of probably at least 5 days of jury selection, I would believe, and maybe longer. And tonight, we're going to talk about what happened today in the courtroom. Are we close to having a jury? One-on-one with John Thomas. We're going to remember Tylee, JJ, and Tammy, and we are going to answer your questions. So this is where we stand tonight. What happened today is that two groups of 16 jurors were brought in. I should say potential jurors. They were brought in today, all 16 at a time. And by the way, we were streaming this on EastIdahoNews.com, our YouTube channel. You can go check that out. It was also on my Facebook page, East Idaho News Facebook, if you want to go back and watch it. It gets kind of tedious, but it was fascinating to be in the courtroom today compared to last year with Lori Vallow's. We were in an overflow room watching a little video feed. The video feed that you all were probably watching, that's what we were watching last year. There is a different feel inside that courtroom. So the first group of 16 was brought in. And what the judge does is he goes through based on the questionnaires that they've answered, and he will say, okay, juror number, well, actually, do any of you have a problem knowing that this case could take 10 weeks? And somebody might raise their hand and say, yeah, I don't get paid for my job if I take 10 weeks off. And the judge could say, okay, and then the prosecution can ask questions, the defense can ask questions, and one of the sides or the judge can move to strike the juror, release them, or they can keep them on and see where it goes. After the group of 16 in the morning was brought in, a few of them were dismissed for different reasons, like a mom who is the caretaker for her 2-year-old, and the dad works full time, and the 2-year-old needs the mom to help go to sleep, things like that, or travel plans, or can't get out of work, training, whatever it may be, health issues. They then just let all the jurors go in the back, and they pull them out one at a time, and they question them. And they get a little bit more invasive in the questioning, such as, what are your views on the death penalty? Or, you said this in your questionnaire, what did you mean by that? Things of that nature. And then the defense or the prosecutors can say, okay, we want to strike them, we want to get them out of here, or we want to keep them. Out of all of those that are kept, the magic number that we have to get to is 50. So 50 people have to survive the selection. Once there is 50, then the defense and the prosecutors will go through and whittle it down to 18. 12 jurors and 6 alternates. So build it up to 50, then narrow it down, and those are preemptory strikes where the defense or prosecutors don't have to have any reason to strike them. They can just say, goodbye. Nothing personal, goodbye. So we need 50. Today we had 2 groups of 16. The morning group went until about 2 o'clock. It was late. Rush out to the car, have lunch, go back in. The evening group, the afternoon group, went until 6 o'clock. Afternoon went a lot quicker. They were kind of more in a hurry, I think, and the judge is like, we got to get out of here. So we need 50. Here's where we're at. 16 have advanced. We have 16 out of 50. 8 men and 8 women. Interesting there. I have notes on each of them. I'm not going to go back and read you the thorough notes, but it is a collection of older men, older women, younger women, different jobs, different occupations, different family situations, different views on the death penalty. That was a big thing here. One elderly man was dismissed this afternoon because he is adamantly opposed to the death penalty. He said in every single case, I am against the death penalty. He was strong in his Catholic faith, and he is totally against it. Other people totally support the death penalty. And if they support the death penalty, the judge then has to ask, well, do you believe the death penalty should be administered in every murder case or just some? And I don't think I heard one person say every murder case. Most just said some. So we have 16. We have 8 men, 8 women. That means that come tomorrow, another group will meet at 9 o'clock in the morning, another group of 16, and they will try to get more out of that group. And I believe it's just going to be one group tomorrow. If I understood the judge correctly at the end of the day, I think they're going to do the one group, and then they have to go through more questionnaires for a potential follow-up group. So tomorrow might be a shorter court day. Don't take me 100% at that, but know that tomorrow could be shorter and that we could get more people there on that jury. So some general observations that I had today. Far less people in court. Now, it is jury selection, and generally there's not as much interest. But last year on Lori Vallow's jury selection day, we were all in an overflow room, and there were probably 50 people, maybe 40. Today, we had maybe 20, and at the end of the day, there were 4 of us. Me and 3 members of the public. Far less media here. The Boise media is here. I'm here. A couple of stations from Salt Lake City are here, and that's about it. So I think that a court TV showed up tonight as I was leaving. They were going live outside of the courthouse, but the media interest is far less. Now, you could argue that because you guys are watching it on YouTube on East Idaho News. I'd love to know your thoughts. Do you think there's less interest, or is it just that it's more accessible to you? As I said, jury selection can be pretty boring. I don't know of a lot of people that would sit through that whole thing. Tom Evans, who I showed you his interview last night, he was there today, and another former juror showed up, a mother. I mistakenly referred to her as Tom's wife on my Twitter, and I was wrong. It wasn't his wife. I didn't see her, but she said it was a little surreal to be back in that courtroom. So those are some of the observations. Some of the other observations is the prosecution's different. Last year it was Rachel Smith, Lindsay Blake, Rob Wood, Spencer Rammel, and Tanya Rawlings. Tanya Rawlings is now a judge. She's gone. Spencer Rammel isn't there. Rob Wood and Lindsay Blake are, but they've brought on Ingrid Batty from the Attorney General's office, and they've brought on Rocky Wixom, who is Lindsay's deputy in Fremont County. So there's a different change of attorneys, and of course there's the change in John Pryor. How was Chad acting today? Chad was acting like how he has at every other hearing. He was focused. He was dressed up in a blue shirt, tie, khaki greenish pants. He not disruptive, just Chad being Chad. I mean, there was times John Pryor kept forgetting to turn on his microphone. At one point, Chad leaned over and turned it on for him. John Pryor had to thank him. I know many of you were talking about, why is the sound issue so bad? Why are the camera issues so bad? Can you zoom in? Can you pull out? That is all on the cord. That's not on us. I wish it was, but it's not. So that is where it stands now. I did want to pull up quickly because I thought it was interesting, at least in my opinion, to see where we were at a year ago today on Lori Vallow's trial as far as the number of jurors we had on day one. So how about this? How about I'm gonna play you John Thomas's interview, and I'll get you that number as far as if we're further ahead with this case versus Lori's or not. But John Thomas has been a defense attorney for quite some time in Idaho Falls. He's represented a lot of serious crimes. Of course, he was brought onto Lori Vallow's case last year, and he agreed to sit down and talk with me about the death penalty case. Couldn't talk specifics about Vallow, but we did touch on it a little bit. I know a lot of you have burning questions for him. It's still in the appeals process, and because he was not the main attorney on it, he just wanted to be careful that he didn't talk out of turn about the case. But he did talk about it with me, some of the aspects. So I'm going to go ahead and roll that interview right now, and we'll come back, we'll talk about it, and we'll take your questions. I'm Nate Eaton, and today I'm talking with John Thomas. For those of you familiar with the Lori Vallow case, you likely heard his voice every day, or if you were in the courtroom, you saw him. We're not going to talk about that today, but we are going to talk about an aspect of the Chad Daybell case, and that is the death penalty. And not just his case, obviously. There's some other cases that are happening in Idaho, and it's been in the news a lot lately. So I asked John if he could come in and kind of explain exactly how this whole death penalty issue works. So thank you, John, for coming in.
Sure.
Let's just get started with, how does an attorney like yourself become qualified in a death penalty case?
So there's two versions of a death penalty qualified attorney. The first version is your first chair. The second version is your second chair. And so in order to become first chair, you have to sit on a death penalty case as a second chair attorney, and then you move up. And so in order to become death penalty qualified as a second chair attorney, you fill out an application. It's about 25 pages long. You have to have done so many cases to trial, felony cases to trial. You're vetted by a group of attorneys, and they decide whether or not you have the specialized skills. You have to demonstrate that you have skills in dealing with expert witnesses, that you have skills in dealing with not only expert witnesses, but high complex litigation, lots of motions, those kinds of things. You have to submit writing samples and those kinds of things. And then they decide whether or not they're willing to allow you to be death counsel. And then if they are, you get assigned a mentor. In my case, it was Jim Archibald. And he agreed to mentor me as a death penalty attorney. And yeah, I've been with him. We've done probably 5 or 6 death cases together. None of them have gone all the way to trial. And we were thinking that Lori Vallow may end up going to trial as a death case. But a couple of weeks before the trial, we ended up getting death penalty taken off the table.
Mm-hmm. Which Jim has said is really the win for you guys as the defense team.
Yeah, that's it. That's what we do. That's what we work for, is to get the death penalty off the table. And if we can't get the death penalty off the table, a win at a death trial would be to either get her life without parole, or to get the defendant, obviously an acquittal, but a lot of times, even short of an acquittal, a win is still not having the death penalty imposed.
Sure. So you were second chair in that case.
Yes.
And had it gone all the way as a death penalty case, you would then have been qualified to be a first chair.
Yeah, theoretically, right. Yeah. I would have qualified to be a first chair, but then you have to fill out another application, get vetted, and that's the only hurdle that that I have not met yet, is haven't been through a death penalty jury trial. And
meaning, for the person watching, well, what's the difference between a first and a second chair?
Not much, really. I mean, the first chair deals with you're kind of in charge of all the experts, of all the witnesses, of all the mental health stuff. And the second chair is your co-counsel, but there's a lot of collaboration, and you're always collaborating with co-counsel. You're meeting with all the experts at the same time. Ultimately, the first chair has the final say. And so if there's a disagreement about how you want to proceed, and the second chair says, well, gee, I think that we should probably go this way, and the first chair says, well, thanks, but I think we're going to go in another direction. And the second chair always says, yeah, okay, you're more qualified. Most of the time the first chair guy is a lot more seasoned and has had more trials and understands the background better.
So what kind of cases in Idaho could be qualified, the defendant, where the prosecutor could say, we're going to go after the death penalty?
So there has to be a murder, and there has to be a homicide. Somebody has to die, and it has to be. There are certain qualifiers that make it a death penalty case. There could be a mass shooting where more than one person dies. There could be something that is specifically atrocious and cruel, like the way that they killed the person. If this person has a high likelihood of or a high propensity to kill again, that's one. If there is a death involving a police officer in Idaho, you get the death penalty. They automatically go for the death penalty if you end up killing a police officer. Let's see what else. If there's specific ones for, there has to be a qualifying. If you're committing a murder that's involved in a rape, a robbery, a burglary, something to that effect, then you're qualified to be a death candidate. So there are a few specific ramifications to doing certain crimes that will push you into that death sentence. Also, if you kill someone while you're an inmate in prison, you're automatically qualified for death.
Oh, interesting. Okay, so the prosecutor has to declare within like 60 days of a charge, right?
Correct.
Arraignment
Once they're arraigned on that charge, the person will plead guilty or not guilty. Generally, in a death case, if it's a murder one case, they'll plead not guilty. And then the state has 60 days from the date of that arraignment to say, yes, we're going to seek the death penalty. No, we're not going to seek the death penalty. Right now, I'm still awaiting 2 cases where death penalty qualified counsel has been appointed, but we're not sure if they're going to seek the death penalty yet.
So what are the differences in a trial for same crime? I mean, I guess we could compare the Chad and Lori trials if we want.
Sure.
Are we going to see differences in how things are argued, or witnesses or evidence versus a death versus non-death?
Sure. Death is different. And there's Supreme Court of the United States cases that say that. Death penalty is just different. You get a lot more leeway in your defense. You can ask a lot more questions. You can put on a lot more witnesses. Everything is on the table on a death penalty case. Everything is mitigation. In a death penalty case, and in the Lori Vallow case, we specifically had to have a mitigation expert, somebody at the outset when we first started the case who could go through Lori's background, go through Lori's her life, basically, turn it upside down and shake it out and find out everything about Lori. And in the Vallow case, he'll have to do the same thing. He'll have to have a mitigation expert who's done all that before now, because in a death penalty case, there's 2 tracks. There's the pre-conviction track, which is called the guilt phase, and then there's the post-conviction track, which is the sentencing phase or the punishment phase. And you have to be prepared for both phases at the outset of the case. So you can't go into a trial and say, well, we're going to win this case, so we don't really need any mitigation evidence. We don't need to be ready for sentencing. The Supreme Court of the United States has said you have to be ready for both phases of the case at the outset. So you have to be ready for the mitigation phase. You have to be ready for the punishment phase while you're preparing for the guilt phase.
Interesting. So could there be some witnesses that you hold for that guilt phase that you don't have or for the penalty phase versus the guilt phase?
Right, absolutely, yeah. You'll have a majority of the witnesses that you'll have on your witness list will be for the penalty phase, because those are, not fact witnesses. Those are witnesses who are going to be able to tell the story of the person who is getting who was convicted of first-degree murder, and they're looking for the death penalty.
So that whole purpose of that second part, once a guilty verdict comes down, if a guilty verdict comes down, preserve their life.
Right, that's it.
And that's what the defense is fighting, and then the prosecution's fighting, put them to death.
Right. And so you have to go in with both phases in mind. You have to go in and say, look, we're going to try to prove that our client is innocent, but if we can't prove that, we still have this backup plan, and we're pushing forward, and we are prepared for both of these phases at the same time.
And one of the differences, too, correct me if I'm wrong, is that the judge won't hand down the sentence.
Correct. It is the jury. The jury is the only one, and it'll be the same jury that is in the guilt phase. So you'll go through the whole trial like a regular trial, and the jury will hear all the evidence. And then once the jury says guilty or not guilty, if they say guilty, then immediately, not necessarily immediately. So if it happens on a Thursday, they might start the new trial on Monday. Mm-hmm. But it will be within days, and it'll be the same jury who hears the punishment phase of it. And so once they found this person guilty or not guilty, if they find them guilty, then they move right into the punishment phase, and the jury will now hear a brand new trial. You'll have a new opening statement. You'll have a new witnesses testifying. The prosecution will put on aggravating witnesses who will say, this person needs to be put to death because of X, Y, and Z. And the defense attorney will put on witnesses who say, no, this person's life has some value. Their life is worth saving, and we need to save that person's life. And when the jury goes back to deliberate, they deliberate on the guilt phase, whether or not they're guilty or not. And then they have to deliberate once again on a whole nother. They go back into the same room, and they all argue over whether this person is worthy of death or not worthy of death. And it only takes one person to say, nope, I'm not going to put this person to death. And if they do that, then the whole deliberation is over.
Really?
Yeah. And then they can't put them to death. It has to be unanimous vote that this person is worthy of death.
Wow. So how long could that penalty phase take? I mean, could that be another week or two?
Could be weeks. Yeah.
Wow.
Because the defense is going to put on lots of witnesses about this person's life. They may put on a third grade teacher who says, Johnny he was such a sweet boy, but he came to school sometimes and he didn't have lunch, or he came to school and he was, you could tell that he had been beaten down by his family, by his parents or siblings or whatever, or different things that happened in his life, which would relate to somebody saying, well, gee, he didn't get a full fair shake at life. They may put on a high school teacher who said, wow, I remember this guy, and he was so nice to these other kids. There was a new kid that came in, and he was the first one to go to this kid and shake his hand and say, hey, he really welcomed this person in. And so that gives him a redeeming value. You could put on somebody who worked in a job with them and said, hey, he was a hard person to deal with, but at the end of the day, he really taught me some serious lessons in my life, and he really showed me my work ethic and how well this went. So mitigation can be anything. It can be anything from a third grade teacher to a military officer who says, I know this person and I know that he's worthy of living in life. There's some redeeming value.
Right. So then the jury, once that portion's finalized, I guess there's going to be a closing argument too from both sides.
Yeah, there'll be a closing argument.
They deliberate, they come back right away or however long till deliberate, and they say, this is the sentence.
Yeah.
And then the judge, that's what it is.
Yeah, there's only two sentences, either death or life in prison without parole.
So they can't do 20 years.
No.
It's got to be one or the other.
Yep. Yep.
Wow. So then we hear a lot about once somebody's been sentenced to death, it taking years and years and years and years for the execution to actually happen.
Yeah.
In Idaho, at least.
Everywhere.
Why is that?
Because you get certain appeals, and there are certain mandatory appeals that they have to do, and certain safeguards. I mean, it takes a lot to kill a person. And if the state and if the government is going to take someone's life We want to make sure absolutely that this person actually did it. You know, I come back to the Chris Tapp case, and I always come back to the Chris Tapp case because it was so jarring for me to read the sentencing memoranda and hear the prosecutor asking for the death penalty. He asked for the death penalty, and the judge ultimately, back then, the judge had the decision to whether, yes, I'm going to give you the death penalty, or no, I'm not going to give you the death penalty. It wasn't up to the jury at that time. It's changed since then. And the judge luckily said, no, I think there's some redeeming value to you. I think there's something in you that is worth saving. And I'm glad he did, because 20 years and 58 days later, we have a guy who was taken out of prison and was released, and now we find the guy who actually did the murder. And so there are a lot of safeguards in there for that specific purpose. We don't want to kill somebody unless they really, really deserve it. The death penalty is reserved for the worst of the worst.
Did that case change your views on the death penalty?
Chris Tapp?
Yeah.
Absolutely. I mean, I was always, you know, I used to be of the ilk of, you know what, if somebody's really that hardened and that bad, then yeah, they should probably get the death penalty. And now how do we even know? You know, that's where I'm at. How do we even know if this person actually did it? Because the evidence, the way the evidence comes out, sometimes there's things that the jury just isn't allowed to hear, and due to different, you know, rules and statutes where people just aren't allowed to testify, or the state doesn't put specific things on, and the defense says, well, we don't want to put that evidence on because it may somehow be misinterpreted. You don't ever get the full story. And so while the system isn't perfect, I certainly don't think that anybody is eligible for death in this day and age. Well, there's too much at stake. Somebody's life is always worth saving, and I think that I don't have the ability to tell someone, yes, I don't think your life is worth saving. I just don't.
You kind of made that point during Lori Vallow's sentencing.
Right.
And you don't have to talk about it if you don't want to. You got hammered a little bit.
I'm sure I did.
Online and whatnot. But
yeah.
that was the point, at least to me, that you seem to be making.
Yeah. You know, I mean, who are we to judge, right? I mean, we all have to end up at the same place in front of the pearly gates, and we're all going to be looking for mercy. And so I don't want to be the one who is saying, yeah, this person should have been put to death. I just don't think that's ever appropriate for a human being to say that this person should be put to death.
And in Idaho, there's the lethal injection or firing squad.
Firing squad now. They haven't quite built the facility yet, so I think they're still working on that. But yeah, I think we're going towards firing squad, which I don't know if it's less humane because you have to have humans pulling the triggers on these guns, and I'm just not sure that we are prepared to say, yes, put me behind that gun. I want to kill someone. It's different when you go hunting and you kill an animal, but when you kill a human being, even if it's in the most humane type of a way where you're in a firing squad and this person has been proven beyond any reasonable doubt that they are the worst of the worst and should be killed off, I'm just not sure as a human being that we're prepared to take that on for the rest of our lives.
Anything you want to add about the death penalty that we didn't get to?
If you're ever on a death penalty case, think about it. I mean, really pour your heart into it and say, is this really the right decision for this particular person? Because you're not just affecting the victim's family who have lost somebody. You're affecting other families, and you're affecting possibly your own psyche, where it comes out years later, sometimes 20 years later, that, hey, this guy was really telling the truth. He really didn't do this particular crime. And we found out that it was actually done by somebody else. I wouldn't want to be in that position and have that on my conscience, that, man, I voted to kill somebody when he actually didn't do it.
And it seems like there's stories every month, every week of those things where someone's on death row and then DNA clears them or something happens.
Yeah.
Well, thank you so much, John. I appreciate your insight and Thank you for explaining a kind of a complicated thing. As you said, we don't really have a lot of these cases that actually go to trial
Right.
and go through all the way. So
Yeah.
this might be the first and the last for a while.